Hello everyone, allow me to introduce myself first. My name is Danilo E. Hui from Polytechnic Kuching Sarawak. My team and I are going to talk about Company Law Topic 2 Incorporation of Company. The following are the documents required in forming a company in Malaysia. The first one is a company profile, a current report that contains basic information of a company, such as the company name, the company number, incorporation date, company type, company status, registered address, business address, and nature of business, the share capital, the directors of officers, shareholders, charges if any, and financial information. The next one is certificate of incorporation or registration of a company. Under the Companies Act 2016, a notice of incorporation of a company will be issued to the customer after incorporation. However, a certificate of incorporation or registration of a company can be supplied if it is requested by the customer. The third one is the particulars of registered address. An information extracted from Section 46, the notification for change in the registered address under the Companies Act 2016, which has been lodged by customer to SSM, that is Suruhanjaya Syarikat Malaysia. It consists of two segments, uh, that is basic company's information, including the company's most recent registered address and changes of registered address information beginning at 31st January 2017. The fourth one is the particulars of directors or officers, an information extracted from Form 49, written giving particulars in register of directors, managers, and secretaries, and changes of particulars under the Companies Act 1965 and Section 58, notification of change in the register of directors, managers, and secretaries under the Companies Act 2016, which has been lodged by the customers in SSM. It consists of three segments. For example, is the company basic information, the company's current directors or officers information, and previous information of the company directors or officers for the last 15 years. The fifth one is the particulars of share capital, and information extracted from Section 78, Return of Allotment of Shares, under the Companies Act 2016, which has been lodged by the customers to SSM. It contains basic information and share details of a company based on the 10th date of the latest Return of Allotment of Shares (ROA) lodged with SSM. The last but not least is the particulars of shareholder, and information extracted from Section 51, Notification of Changes in the Register of Member, under the Companies Act 2016, which has been lodged by customers in SSM. It contains basic information and changes of shareholding of a company based on the 10th date of the latest change in shareholding lodged with SSM. The following are the example of documents required to forming a company in Malaysia from the SSM website.
Hello, my name is Abdul Rahim. My matrix number is 05T8022F1030. This is relevant step to register a company using micro ID. Step 1. Preparation. Before using micro ID, you should have the necessary information and documents ready, including proposed company name, business activities, and description, a registered office address, information about directors and shareholders, memorandum, and articles of association. Step 2. Create an account. Visit the micro ID website and create an account. If you don't already have one, you will need to provide your personal detail and contact information. Step 3. Name search and reservation. Use MicroID system to check if your desired company name is available. If it is, you can reserve it through the platform. Step 4. Complete the application. Fill out the required form and provide all necessary information about your company, including director and shareholder details, register office address, and business activities. Step 5. Memorandum and Articles of Association. Draft or upload your memorandum and articles of association, which outline the company's rules and regulation. Step 6. Submit documents. Upload all required documents, including M&A, to the MicroID platform. Ensure that all documents are in the specified format. Step 7. Payment. Pay the necessary fees for company registration and other associated costs. MicroID typically provides payment option on their platform. Step 8. Review and approval. Your application will be reviewed by the Components Commission of Malaysia, SSM. This process may take some time and you may be required to provide additional information or clarification. Step 9. Cer- Certificate of Incorporation. Once your application is approved, you will receive a certificate of incorporation, which officially register your company. This document is essential for legal and business purposes. Step 10. Compliance and reporting. Ensure ongoing compliance with Malaysian corporate regulation, including filing annual returns and maintaining proper accounting records. That's all from me. Thank you.
Hi, my name is Daniel Francis, matrix number 05DT22F1048. Today I'll be explaining on what is separate legal entity. So, separate legal entity is a distinct legal structure, typically in the form of corporation or limited liability company, that is also considered separate from its own owners or shareholders. This separation means that the entity itself can own property, enter into contracts, incur debts, and can be held liable for legal obligations independently of the individuals who manage or own it. In practical terms, this separation of legal entities provides certain advantages, such as limited liability for the owners, which means their personal assets are generally protected from the entity's debt and legal liabilities. It also allows for perpetual existence, meaning that the entity can continue to exist even if the ownership changes. This concept is fundamental in business and corporate law and is often used to structure businesses for various legal and financial purposes. So that is all for separate legal entity. Thank you.
Hi, my name is Mohammad Nur Faiz. My matrix number is 05DAT22F1039. The following is Fake Salomon v. Salomon Company Limited. In 1892, Salomon decided to convert his prosperous business into a limited company, and for that purpose, Salomon and Company Limited was formed with Solomon, his wife, his daughter, and his four sons as members, and Solomon as managing director. Then, the company purchased the business of Solomon for $39,000. The price was satisfied by $10,000 in debentures, conferring a charge over all the company is asset. $20,000 in fully paid up, $1 share, and the balance in cash. Seven charges 7 shares were subscribed in cash by the member, and the result was that Solomon held 20,000 one share out of 20,000 7 share issue, and each of the remaining six share was held by a member of his family. The company almost immediately ran into difficulties, and only a year later, the holder of the debentures, Solomon, had transferred his share to another person upon a receiver, and the company went into liquidation. Then, on liquidation, the value of asset was divided as $6,000 for liabilities, $10,000 for debentures, and $7,000 for unsecured debts. After paying off the debenture holder, nothing will be left of for the unsecured creditors. Thus, an action was brought by the liquidator against Solomon, holding him liable to indemnify the company against the company's trading debts. Thank you.
Okay, my name is Liu Chunpo. Today I want to present the Salomon v. Salomon Company Limited. This the judgments. The Court of Appeal declared the company to be a meth, reasoned the Salomon had incorporated the company contrary to the true intent of the then Companies Act 1962, hereinafter to be referred to as the Act, and that the company had conducted the business as an agent of Solomon, who should therefore be act, be responsible for the debt incurred in the course of such agency. However, upon appeal, the House of Lords reversed the above ruling and unanimously had there. As the company was duly incorporated, it is an independent person with its right and liability apparent to itself, and that the motive of those who took the part in promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. In the present case, the Company Act of 1962 provided that any seven or more persons associated for a lawful purpose may, by subscribing their name to memorandum of association and otherwise complying with the provision of the Act in respect of registration from a company with or without limited liability. The Act further provided that no subscriber shall take less than one share. That that there were seven extra living persons who held share in the company was never adopted. Where the capital of the company is owned by seven persons in equal shares, with the right to equal share in the profit, or whether it is almost owned by one person who takes practically the whole profits. It does not concern a creditor of the company. The company thus lost its identity if the bulk of its capital is held by one person. The company at law is an altogether different person from its subscriber or shareholder. And the last is since the company fulfilled all the requirements of the Act, the court held that the company had been validly formed and was a real company. That's all for me. Thank you very much.